All rise. Voulez-vous lever? The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Vous asseoir.
Good morning, Mr. President. The situation in the Democratic Republic of the Congo, in the case of the prosecutor versus Thomas Lubanga Dyilo, case reference ICC 0104-0106. And for the record, we are in open session.
Thank you very much. My name is Piotr Hofmański. I am the presiding judge in the appeal arising from the case at the microphone. Okay. I will start from the beginning. My name is Piotr Hofmański. I am presiding judge in the appeal arising from the case of the prosecutor against Thomas Lubanga Dyilo. My fellow judges in this appeal are Judge Boyosuji, Judge Howard Morrison, Judge Luz de Carmen Ibanez Carranza, and Judge Salome Balongi-Bossa. May I ask the parties and participants to introduce themselves for the record, starting with the defense.
L'équipe de défense est représentée par Virginie Lefebvre sur ma gauche, qui est case manager dans le dossier, Jean-Marie Bijoux-Dubal sur la droite, qui est le conseil adjoint dans cette affaire, et moi-même, Catherine Mabille, le conseil principal. Merci, Monsieur le Président.
Thank you very much. And then victims VO1.
L'équipe VO1 est représentée par moi-même, Evelyne Ombeni, et notre stagiaire, Madame Estelle Veravez.
Thank you very much. And victims VO2.
Bonjour Monsieur le Président. L'équipe VO2 est représentée par Maître Joseph Keta, assisté de Sylviane Gloginon.
Thank you very much. And then OPCV.
Good morning, Mr. President. The Office of Public Counsel for Victims is composed today by Ms. Sarah Pelé, Counsel, Ms. Caroline Walter, Legal Officer, and myself, Paulina Massida, Principal Counsel.
Thank you very much. And Trust Fund for Victims.
Good morning, Your Honor. The Trust Fund for Victims today is represented by Mr. Shechval, Associate Legal Officer, Mr. Trust Fund Lichtenberg, Legal Associate, and myself, Peter de Baan.
Thank you very much. Today, the Appeals Chamber is delivering its judgment on two appeals filed pursuant to Article 82(4) of the Statute by Mr. Lubanga and the VO1 group of victims against the decision setting the size of the Reparations Award for which Thomas Lubanga Dyilo is liable, which Trial Chamber 2 issued on the 15th of December 2017. The Trial Chamber decision will be referred to as the impugned decision. The Appeals Chamber's judgment was rendered unanimously, with Judge Boyosuji and Judge Ibanez Carranza filing separate opinions. The summary I read today is not a part of the written judgment. Please note that only the written judgment and two separate opinions were authoritative. Mr. Lubanga was convicted on the 14th of March 2012 of the crimes of conscripting and enlisting children under the age of 15 years into the patriotic forces of the liberation of the Congo and using them to participate actively in hostilities. On the 7th of August 2012, Trial Chamber 1 issued a decision on reparations, which was subsequently appealed. The Appeals Chamber on the 3rd of March 2015 rendered a judgment in relation to those appeals. The Appeals Chamber amended Trial Chamber's 1 decision and also issued amended reparation order. In its judgment, the Appeals Chamber found, among other things, that it was, I quote, appropriate to exceptionally seek the Trust Fund's assistance in requiring that it provide the anticipated monetary amount that it considers necessary to remedy the harms by the crimes for which Mr. Lubanga was convicted. End quote. The Appeals Chamber stated that the Trial Chamber's decision on the amount of Mr. Lubanga's liability for reparation would be appealable. It is the Trial Chamber's decision on the 15th of December 2017, the impugned decision, which set the amount of Mr. Lubanga's monetary liability, which has now been appealed. In that decision, the Trial Chamber held Mr. Lubanga liable for reparation to the sum of 10 million US dollars in respect of 425 victims it found eligible for reparations and any other victims who may be identified. On the 15th of January 2018, victims V01 and Mr. Lubanga filed notices of appeal against that decision. Mr. Lubanga has raised 6 grounds of appeal against the impugned decision, and victims V01 have raised 3. Before addressing these grounds, the Appeals Chamber considers 4 preliminary issues. Briefly, the Appeals Chamber rejects victims V01 apparent request to challenge the standing of the OPCV in these appeals. Accepts the OPCV's consolidated filing of a response despite this not being expressly provided for in the provisions. Rejects the OPCV's request to dismiss the appeal's outreach, finding this request to be unfounded, and rejects Mr. Lubanga's request for suspension of the Trial Chamber's decision of the 7th of February 2019, noting that that decision was not under appeal. As certain grounds of appeal overlap, the Appeals Chamber grouped them with 4 grounds addressing the system of the award of reparation, 3 grounds addressing the assessment of the individual requests and the standard of proof, and 2 concerning other issues. The 4 grounds of appeal which concern the system for the award of reparations are Mr. Lubanga's 1st and 4th grounds of appeal and victim V01's 1st and 2nd grounds of appeal. These grounds of appeal raise the question of the correctness of the Trial Chamber's approach or methodology in deciding of the monetary amount of reparation for which Mr. Lubanga was held liable, in addition to its decision to decide on the eligibility for reparation of certain individual victims. Together, they raise issues that concern the system in place for the award of collective reparations. Under his first ground of appeal, Mr. Lubanga essentially argues that the Trial Chamber erred in taking into account victims who had not filed requests for reparation when it had not found exceptional circumstances to do so. He argues that the statute only allows for this in exceptional circumstances. The Appeals Chamber considered that the restriction argued by Mr. Lubanga does not exist in the statute and that it would be incorrect to assume that the number of victims may only be established based on the individual request for reparation received by the court. The Appeals Chamber considered that it would be undesirable for the trial chamber to be restrained in the determination simply because not all victims had presented themselves to the court by making a request. In making that determination, the trial chamber should consider the scope of damage as it is in the current reality based on the crimes for which the convicted person was found culpable. The Appeals Chamber considered that in deciding what reparations are appropriate, a trial chamber must take into account the rights of the convicted person. The reparation order must not go beyond the crimes for which he or she was convicted. The convicted person must be given a sufficient opportunity to make submissions on the scope of reparation, the scope of victimhood to be repaired, the type of reparation, etc., so as to comply with the requirements of fairness. If the trial chamber resorts to estimates as to the number of victims, such estimates must be based on a sufficiently strong evidential basis. Any uncertainties must be resolved in favor of the convicted person, for instance, by assuming a lower number of victims or by discounting the amount of liability. The Appeals Chamber rejected this ground of appeal. Under his fourth ground of appeal, Mr. Lubanga argues that the trial chamber erred in not making an award against him based only on the actual cost of the collective award that was made. The Appeals Chamber considered that the amount of the convicted person's liability should be fixed taking into account the cost of reparations considered to be appropriate and that are intended to be put in place, which can include reparations programs and the different harms so far suffered by the different victims, both individual victims, direct and indirect, in addition to, in particular circumstances, the collective of victims. In setting the amount, the trial chamber must also ensure that it takes into account the convicted person's rights and interests. The goal is to set an amount that is fair and properly reflects the rights of the victims, bearing in mind the rights of the convicted person. If the information and evidence upon which the trial chamber relies does not enable it to set the amount of liability with precision, for example, because it cannot obtain precise information of the costing of specific reparation programs, then it might, with caution, consider whether to rely on estimates. The Appeals Chamber considered that two sums of money taken into account by the trial chamber fixing its award: $3.4 million in respect of the 425 applicants it found eligible, and $6.6 million in respect of other victims who have not yet come forward. It found that although the trial chamber could have been clearer as to how it fixed the sum in question, Mr. Lubanga had not demonstrated an error in the trial chamber's findings. The ground of appeal is rejected. Regarding their first ground of appeal, victims VO1 argued that the trial chamber erred in assessing the individual requests submitted by victims and exceeded the mandate given to them by the Appeals Chamber. The Appeals Chamber considered that neither the relevant provisions nor the Appeals Chamber's previous judgment prevented the trial chambers from proceeding in the manner in which indeed it did. It rejected the first ground of appeal. Regarding the second ground of appeal, victims VO1 argued that the trial chamber erred in assessing eligibility for reparation based on different procedures, that the participating victims were misled by contradictions arising out of the various chambers' decision and interpretation of the trust fund, and that its participating victims were, as a result, discriminated against. The appeals chamber considered that it is clear from the proceedings that the participating victims should have been on notice that the trial chamber intended to re-examine their status as victims for the purposes of the reparations proceedings. The part of the argument was therefore rejected. As to whether the previously participating victims were misled by contradictions between various decisions and were disadvantaged vis-à-vis future victims, the appeals chamber considered further the history of the proceedings and accepts that the differences between these approaches and potential ambiguity created might have led to uncertainty as to what was required of potential victims submitting requests. They may have also affected the manner in which the entities concerned interviewed potential victims and prepared their dossiers. It is conceivable that, as a result, some accounts included in the victims' dossiers were more detailed than others and attached more supporting documentation than others. This, in turn, may have led the trial chamber to find some of the dossier to insufficiently substantiate the potential victims' allegations regarding their victimhood. The appeals chamber finds that the trial chamber's overall procedure for the eligibility assessment failed to ensure equal conditions for all victims and amounts to an error. This error materially affects the impugned decision, as some of the victims concerned may have been found eligible had they known more fully what was expected of them in submitting their dossiers, and the trial chambers could have given them an additional opportunity to supplement their dossiers and clarify their accounts. The appeals chamber also extends this ruling to the other victims whose claims were rejected but who were not represented by victims VO1. The appeals chamber therefore amends the impugned decision to the extent that the trial chamber finds that 48 persons had not proven to the requisite standard that they qualify as victims for reparation in this case. The impugned decision is amended such that the victims whom the trial chamber found ineligible to receive reparation and who consider that their failure to sufficiently substantiate the allegations, including the supporting documentation, resulted from insufficient notice of the requirements for eligibility, may seek a new assessment of the eligibility by the trust fund, together with other victims who may come forward in the course of the implementation stage, and is envisaged to be by the trial chamber in the impugned decision. The appeals chamber also finds that any recommendations as to eligibility made by the trust fund shall be subject to the approval of the trial chamber. Regarding victims V01's third ground of appeal, they argue that the trial chamber disregarded the assessment of eligibility carried out by the trust fund and make arguments as to how the assessment was done. In view of its conclusion made under the second ground of appeal, the appeals chamber considered that there was no need to examine this ground of appeal and it's therefore dismissed as moot. The following grounds of appeal related to actual assessment on 473 individual requests for reparations and to the applicable standard of proof, as well as to the determination of the 425 victims are only a sample of the potentially eligible victims, and that hundreds and possibly thousands more victims suffered harm as a consequence of the crimes of which Mr. Lubanga was convicted. It is comprised of Mr. Lubanga's second and third grounds of appeal and victims V01's third ground of appeal, the conclusion on which I have just summarized. Under his second ground of appeal, Mr. Lubanga challenged the trial chamber's conclusion on both the 425 claimants it found eligible for reparation and its conclusion as to the hundreds and possibly thousands other victims, including ones who may come forward at the implementation stage. The Peace Chamber addressed the arguments raised and concluded that Mr. Lubanga has failed to identify an error. Under his third ground of appeal, Mr. Lubanga argues that the trial chamber erred in the reductions it permitted to the requests for reparation which were disclosed to him. He submits that the level of reduction prevented him from responding properly. The Peace Chamber noted that the guiding principle for trial chambers must be ensure that the convicted person, as a party to the litigation, has a meaningful opportunity to challenge the information on the basis of which a chamber will make an award against him or her. The Peace Chamber noted that the ultimate purpose for which the trial chamber used the request for reparation in this case was limited. In this regard, even though the trial chamber made findings as to the eligibility of the 473 victims who filed this year before it, it is not clear to the Peace Chamber that the overall monetary award made, $10 million US, would have changed had the number of eligible victims been different. The overall award made was also based inter alia the trial chamber's finding as to the additional hundreds and possibly thousands of other victims, some of whom may be identified during the implementation of reparations. The Peace Chamber recalls in this context that the trial chamber assessed the 473 dossiers as a sample in the context of determining Mr. Lubanga's overall monetary liability, and did acknowledge that there was additional victims who had not yet been identified. These considerations guided the Peace Chambers in its consideration of the specific arguments made by Mr. Lubanga. Having addressed them, the Peace Chamber found that he had failed to identify an error. This ground of appeal was therefore rejected. The two remaining grounds of appeal of Mr. Lubanga's fifth and sixth grounds of appeal. The fifth ground raises the issue of how to take into account, when calculating the monetary value of personal liability for reparation, a convicted person's role in the commission of the crimes in question, also vis-à-vis other possible co-perpetrators, and how to take into account other issues that he or she may raise with a view to mitigating his or her liability. Mr. Lubanga's sixth ground of appeal raised the issue of the application of the non ultra petita rule in reparation proceedings before the court. The appeals chamber rejected both grounds of appeal, finding that Mr. Lubanga failed to identify an error in the trial chamber's conclusion. The appeals chamber concludes that the impugned decision is confirmed, subject to an amendment which has been already described. As stated, Judge Ibosuji will file a separate opinion to this judgment. Judge Ibanez Carranza will also file a separate opinion in which, while concurring with the outcome of the common judgments, she elaborates in depth and clarifies various issues regarding this case. She considers, from relevant grounds of appeal in the submission advanced by the parties, as well as activities performed by the Transfer for Victims and the methodology followed by the trial chamber during the implementation process, there are serious misunderstandings, misappreciations, and difficulties regarding the following issues. 1. The nature of the reparation proceedings before this court and the nature of scope of reparation for crimes under the court's jurisdiction. 2. The scope and extent of damages and harm and the scope of victimhood to be repaired in the case at hand. And 3. What do adequate, appropriate, and effective reparations entail? Consequently, Judge Ibanez Carranza's opinion addresses this issue to provide further depth and clarity on these fundamental matters, and with the ultimate goal to strengthen the common judgment and provide further guidance for the implementation stage. In Judge Ibanez Carranza's view, the common judgment has addressed the appeals in a practical manner, and the separate opinion addresses in depth these topics that, in her view, are extremely important to shed light to this case. Despite the long time by the parties awaited, she considers that this is the most important case in reparation before this court because it refers to a very broad scope of victimhood that includes potential victims and specific type of damages, all of which has been considered as the basis to determine Mr. Lubanga's amount of liability. These reasons further motivates her to issue a separate opinion. With this consideration in mind, Judge Ibanez Carranza explains in detail the reparations proceedings in atrocious crimes, such as those under the jurisdiction of this court, which also constitutes gross human rights violation, are judicial in nature and emerge from the criminal conviction and include the harm and damages emerging from the breach of the criminal prohibition of the crime under the harm and damages emerging from the grave violation to the core human rights involved. Consequently, and in light of the foregoing, she considers that by virtue of the mandate imposed in Article 21.3, read in conjunction with Article 75.6 of the Statute, international human rights law and human rights standards, guidelines and principles must be considered and applied in reparation proceedings. Furthermore, due to the judicial nature of reparation proceedings, the Transfer for Victims, which is an administrative entity created by the Assembly of State Parties, performs a complementary and supporting role in this regard. Its actions are always subject to judicial control, reviewed, and final approval by the trial chamber. This supporting role is different to the Transfer from Victims assistance mandate. The latter is not linked to any reparation proceedings and as such should not be confused with the former. Judge Banis Carranza explains that the type of harms as suffered defines the type of victims. When repairing victims' harm, attention should be paid to the specific characteristics of each victim, individually, direct or indirect victims, and collectively. In the case at hand, there is a specific harm to child soldier, that is the damage to the project of life, that must be recognized and repaired together with other types of damages. Likewise, the damages to the community must be recognized and repaired. With respect to the eligibility of potential victims, she maintains that the trial chamber was entitled to conduct it and to include such victims in the Reparations Award. This is because the conviction and sentencing decision in the case at hand already made determination as to the existence of potential victims, and the trial chamber had the mandate to follow such determination in the reparation proceedings. Yet, even if there had been no determination in this respect, she acknowledges that there was exceptional circumstances that would have enabled the trial chamber to search, screen, and determine potential victims and consider them for reparation in setting the final amount of Mr. Lubanga's liability. The burden of proof in reparation proceedings for atrocious crimes, such as those in the present case, cannot be placed exclusively on the victims. The court, under Rule 97.2 of the Rule of Procedure of Evidence, has the power to appoint experts to determine the harm. In case of mass criminality, where victims have lost everything, and regarding issues of scope of victimhood, damages, and the link of causation, the court must rely on the support of multidisciplinary technical professional team of experts. This must be done also in the implementation stage by the Trust Fund victims, especially in the process of screening, eligibility, and determination of the potential victim with the aim to awarding reparations. In case of crimes that constitute gross violation of human rights, such as those under the jurisdiction of the court, the human rights to reparation must be premised on the human rights to true and justice. Reparations must be adequate, appropriate, and effective, and must be based on the principle of restitutio in integrum. They must restore dignity and restructure the victims as a human being and his or her entirety in his or her individual, communal, and social dimension. To this end, the reparation process and the implementation stage in the instant case must be guided by internationally recognized human rights and standards. This brings me to the end of the summary. Finally, I stress that the summary is not authoritative. The authoritative version will be notified. I thank the court reporters, the court interpreters, and the other register staff for the invaluable assistance today in holding the hearing. The hearing is now adjourned.
All rise.